welcome to today's program titled Guidance on State and Local Paid Sick Leave Laws, Part 5, spotlighting practical tips on navigating the National Paid Sick Leave Law Patchwork in 2021. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for the CLE credit. Copies of this webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Tracy Billows. Tracy, please go ahead.
Thank you, Kate. Thank you all for joining us today. I'm seeing the number tick up here in terms of attendance on our webinar. I'm so thrilled to be joined by Anne-Marie, Josh, and Marlon. You have probably seen all of us speak on this topic multiple times. Maybe even some of us together, but really you are in for a tremendously informative session today. We are covering all things paid sick leave, compliance options and considerations. You have from the East Coast to the Midwest to the West Coast, and Marlon, Josh, and Anne-Marie are our preeminent experts in this area and will be sharing incredibly important information. Next slide, please, Kate. Here's quickly sort of the topics we will be covering. First, the state and local paid sick leave patchworks. I know we've talked about that in many different shapes and forms, and unfortunately, folks, we're still there, and we'll give you some tips on navigating. We're going to talk about compliance options from a nationwide perspective. What does that look like? What are those considerations? We're also going to talk about PTO and PSL compliance and California nuances. I don't mean to pick on California, but we all know that California often is the outlier in many of these, and Anne-Marie is going to offer those perspectives. Unlimited PTO and PSL compliance plus California nuances. We get these questions all the time, and notice we put unlimited in quotes. We're going to talk about what that means nationwide, as well as what that means in California. So without further ado, let's get into the substance of the program, and I'm going to turn this over to Marlon to kick us off. Thank you, Marlon.
Thank you, Tracy. So I'll be speaking about the state and local paid sick leave patchwork. And on the next slide, you'll see that as of October 1st, 2021, there were 63 paid sick leave mandates in the U.S. This includes mandates at the federal, state, as well as the local level. And when I say paid sick leave, it includes more than just what you think about when you think of paid sick leave laws. These mandates include laws that deal specifically with paid sick leave only, with paid safe leave only, or combined paid sick and safe leave. Some of these mandates are public health emergency mandates, PTO mandates, COVID-19 specific emergency paid sick leave laws, as well as vaccine laws. So this captures all those different types of mandates. At the federal level, currently there is one mandate that is in effect, and that is the executive order that provides paid sick leave for many employees of certain federal contractors. We also had the Families First Coronavirus Response Act. However, that sunset at the end of last year, and the voluntary leave option for that as well expired recently at the end of September. At the state level, we have 17 states plus Washington, D.C. that have at least one of these types of mandates. You'll see that Maine and Nevada are off to the side because those are the only jurisdictions at the state level that have PTO laws. So that means that employees can use the leave for any reason whatsoever. It doesn't have to be limited to specific reasons for paid sick or paid safe leave. We have 27 municipalities that have at least one of these types of paid sick leave ordinances. Bernalillo County is a PTO ordinance, so that joins Maine and Nevada. But you'll see that in the municipality section, a lot of these local laws are in California. I also want to point out here that there are 3 jurisdictions that are in red font, and that is because Dallas, Texas ordinance has been permanently enjoined, and the Austin, Texas ordinance and San Antonio ordinance have been temporarily enjoined because courts found that they were unconstitutional and violated the Texas Minimum Wage Act. So because of these laws are unlikely to make a comeback and unlikely to ever go into effect, which is why they are there in red font. Now, for those of you who are doing the math and thinking that there's one federal law, 17 states plus DC, that's 19, plus 27 municipalities, that's 46. So where do we get this 63 number from when we say there are 63 mandates? Well, the reason for this is because some jurisdictions have multiple mandates. So for example, New York has a regular paid sick leave law, a COVID-specific emergency paid sick leave law, and a separate vaccine paid leave mandate. So there are 3 mandates in New York alone. Colorado has 2 mandates. There's a general paid sick leave law there, as well as a public health emergency leave law. Nevada has a general PTO law, a separate vaccine mandate, and yet a separate industry-specific mandate, which is the hospitality workers COVID-19 paid sick leave law. So because these jurisdictions have multiple laws, we get to that 63 number, even though there are only 46 jurisdictions that have laws currently. And this number is always changing. As of the end of 2020, there were 69 total mandates in the U.S., but because COVID-19 paid sick leave laws sunset, we are now down at 63. And as you see on this slide, is that the landscape is always changing. And I highly encourage you to click on the link when you get a copy of the slides later, and you can see how much the landscape has changed. You can see this from before 2014 through 2020. And I just want to note 3 non-COVID related updates from this map. So there's a new Virginia statewide paid sick leave law that only applies to home health care workers. That went into effect on July 1st of 2021. New Mexico passed a statewide paid sick leave law, and that went into effect, that is going into effect on July 1st of 2022. And Allegheny County passed a paid sick leave law recently. Most provisions of that, it is yet to be determined when the effective date will be. So make sure you follow our updates to find out when that will go into effect. So I highly recommend that you check out this great resource. And with that, next slide. So in terms of COVID-19 laws, there were many updates relating to that as well. I'm not going to go into every single update that happened because that would take the rest of this webinar and will probably require even more time. But what I will talk about is just the types of laws that we've seen during this time in connection with COVID. So we have 4 main groups. The first group, the orange group, consists of entirely new laws, or this could be executive orders, other emergency orders, or actual laws that deal with non-vaccine COVID-19 absences. And even within this category itself, we saw a number of different kinds of laws. In some jurisdictions, we had temporary supplemental COVID-19 paid sick leave laws. We saw this in a lot of local jurisdictions in California, in Washington, D.C., and Pittsburgh, amongst others. Some of these laws were COVID emergency paid sick leave mandates with no sunset dates that were tied to only COVID-19, like we saw in New York. There were also some general public health emergency mandates that dealt with public health emergencies beyond COVID, like we saw in Colorado. Group 2, the blue group, consists of entirely new mandates exclusively for COVID-19 vaccine paid leave. So these laws provided leave specifically for COVID-19 vaccines. We saw this in New York as well as in Nevada. Group 3, we saw some jurisdictions that made amendments to their already existing laws and regulations in response to COVID-19. So New Jersey and Seattle are great examples of jurisdictions that did that. And then finally, Group 4, the purple group, general non-binding guidance regarding applicability of an existing paid sick leave law in light of COVID-19. And this included many jurisdictions like Arizona, but many more. These jurisdictions basically released some sort of non-binding guidance that explained how the current law applied to COVID situations. And with that, next slide, you'll see on this slide here the jurisdictions that had these COVID-19 laws, and it's a very colorful slide because we tried to capture what kind of laws these jurisdictions passed. So you'll see some jurisdictions like Arizona are only in purple because they only had one type of law. But then we get to New York, number 31, which is in blue and orange. And the reason for that is because it had a vaccine leave law as well as a COVID-19 specific law. New Jersey, for example, is in purple and in green, and that's because it amended its general paid sick leave law in light of COVID, and it also had non-binding guidance regarding its already existing law. You'll also see a lot of strikeouts in this slide, and the reason for that is because these laws sunset. Many of them sunset at the end of September of this year, and that is the reason why they are crossed out on this slide. Next slide, please. And now that I gave you all that information, we're going to have a pop quiz. I'm just kidding. We just have a few polling slides, and we'd really appreciate it if you could please look to your right and click the answer that corresponds to the answer that you want to select and click submit. So for this question, please let us know in how many states does your company or organization operate? So 1 for fewer than 5 states, 2 for 6 to 15 states, 3 for 16 to 25 states, and 4 for more than 25 states. So I will give you just a few seconds there to answer this question. Okay, and if we can get those results now in. Okay, great. So I see that most of you are in more than 25 states. So this patchwork of sick leave laws is definitely impacting you. And the information you're going to get in this webinar will be great in navigating that. Next poll, please. So this is a simple yes or no, whether your company or organization has employees in California. And I will give you just a few seconds to answer this polling question. Okay, great. And if we can get the results on this, please. Again, most of you, about 72%, have employees in California. So this will be a very helpful webinar because we're going to have Anne-Marie giving us the California callouts in a little bit on this. And then final poll, please. So what kind of policy does your company or organization currently use for paid sick leave compliance? 1, if you use individual paid sick leave policies for each location. 2, if you use a one-size-fits-all or one-size-fits-most policy with addenda. 3, if you use a PTO policy granting or accruing specific amount of leave, so opposed to an unlimited PTO policy. 4, if you use a unlimited PTO policy. And 5, if you use any combination on the above, depending on your employee population. So if you have, you know, let's say a PTO policy for salaried employees, but you use paid sick leave policies for hourly employees, that would be the option you select. And can we get the results on this poll, please? Okay, so I actually see a great mix of answers to this. So it looks like a lot of you are choosing at least one of these options and complying with paid sick leave. So again, the coming slides are going to be very helpful in navigating through these. And with that, I will turn it over to Josh.
Great. Thank you so much, Marlon. Good morning, good afternoon, everyone. Thank you for joining us for this part 5 of our paid sick leave webinar series. As Marlon and Tracy mentioned, we have a lot of really great information to go over with you. You know, some of our other parts of this series, we focused on specific locations, which has been incredibly helpful, COVID-19 paid sick leave mandates, even the federal prospects during our last segment. But of all those different topics, this one in particular, I think has the most sort of relevance to day-to-day operations for companies, you know, tips and practical nuances that companies are working through. As we saw a couple of slides ago on that first poll, so many of you have operations in more than half of the states, making how do I deal with this patchwork that, as Marlon said, is always changing, constantly shifting on us. How do we deal with that patchwork? And there are different compliance options. You know, fundamentally, one of the very first questions for a company to think through after it identifies which laws are relevant to it is, do I want to comply with the paid sick leave laws via a paid sick leave only policy, right? So I have separate buckets of sick, vacation, and personal time, or do I want to comply via a PTO policy, a single bucket that swoops in all 3 of those topics? We'll be discussing both options. We're going to start with the former, with the paid sick leave as the compliance vehicle. What's important to remember right off the bat, as you'll see on the next slide, please, is that there are a variety of different considerations that are at play when you're thinking about paid sick leave, multi-state and nationwide issues. This list, these 6 bullet points, this is not an exclusive list by any means. What's interesting about this list, too, is that the overwhelming majority of these points will also be applicable to the PTO discussion we're going to have in the next section of this webinar. So again, you've hit the ground running, you've identified your paid sick leave laws and mandates that are relevant to you and your operations. What are some of the things to think through and to think about? One of the first ones that companies will come to us with and that they'll need to iron out is, how do I want to deliver the paid sick leave to those workers? Do I want to deliver the paid sick leave through an accrual system or through a front-loading system, some combination of the 2 perhaps? Accrual is mostly 1 hour of paid sick leave for every 30 hours worked. That is sort of the baseline accrual rate that these laws will bring to the table. There's only one law, it's out in Rhode Island, that requires accrual based on hours paid rather than hours worked. There are different types of accrual caps, though, right? Beyond just the threshold, the amount of time the workers need to accrue under the different laws, because that varies. There are also different types of accrual caps. Some laws have annual caps. Some laws have point-in-time or rolling caps, where the worker accrues up to a certain threshold, uses that time, once they get to that threshold, the accrual stops. They use some time, draw the balance down, then the accrual begins. There are some laws that have a hybrid of those 2, an annual accrual and a point-in-time rolling accrual, so those need to be operated in tandem within your system. And then even a handful of laws don't permit any cap on accrual at all. So you have these different caps that make an accrual system complicated if you are triggering 20, 30 of these non-COVID paid sick leave laws. Front-loading, as it sounds, is an upfront grant of paid time off, paid sick leave that workers receive at the start of each benefit year and upon hire. Which one to use really depends on a variety of factors. For example, if you have a large part-time population or you have a lot of turnover in your workforce, front loading for at least that group of workers might not make sense because it would be giving them a windfall, right? Part-timers might not work enough hours throughout the year to have earned the full amount of the front load, so you're giving them a windfall. Front loading also has a downside to it because you're giving the time to the workers right at the start of each benefit year, which can increase absenteeism because the workers have access to that time for a greater period of months over the course of the benefit year, as opposed to accruing it based on hours worked throughout the year. So you can end up with a situation where a worker takes a lot of time off at the end of your benefit year, gets the new front load, and takes a lot of time off at the start of the next year. Over a 2-month period of time, the employee could have 2 weeks, maybe even more, of absenteeism. All of it would be job protected. On the other hand, front loading comes with certain administrative ease that, compared to accrual. You avoid the 1 hour for every 30 hours work tracking. You avoid the different types of accrual caps for the most part. You can avoid accrual with a front load, not everywhere, but in most places. And front loading also, in a majority of sick leave locations, allows you to avoid year-end carryover. Now, it's worth a quick mention. A lot of companies have a misnomer about use it or lose it and front loads. Most companies will think if I get a grant of time, or if I give a grant of time to my workers that's sufficient, the right amount at the start of each year, I can avoid year-end carryover. And while that's true in most sick leave locations, there are around 10, maybe a little bit more, where a front load does not get rid of year-end carryover obligations. So it is worth keeping in mind that that is not a blanket, use it or lose it option if you're front loading, but still greater administrative ease compared to accruals. So those are some of the accrual versus front loading options. As I mentioned a minute ago, some companies will have front loading for certain workers, perhaps full-time, and then accrual for other workers, perhaps part-time workers. Then that would lead to the practical complication of what about when workers transition from full-time to part-time or vice versa. So you have to account for it in that way if you're going to split between front-loading and accrual. The next two topics, remote work and mobile workers, and then one size fits all, one size fits most, have a lot of overlap. So I'm going to discuss them in tandem for a bit. The pandemic has obviously highlighted the need or the option of remote work. It's something a lot of employees are looking for from their employers. It's something a lot of employers are considering rolling out in a long-term fashion rather than just as a temporary response to the pandemic, allowing complete telework or hybrid work schedules. Those are certainly part of the discussion now for most industries, most employers around the country. Mobile workers, workers who move around within a given week or month to different cities and different states, is also relevant for a number of different jobs. Those obviously create issues when you have a paid sick leave patchwork because they can be triggering different paid sick leave laws. If I am working at a work site in one jurisdiction but working from home in another jurisdiction, which benefits are going to prevail? And if you have a paid sick leave policy by location approach, as Marlon mentioned in that third polling question, which I saw a handful of folks do have, that can be quite tricky when you have a mobile workforce or a remote workforce because they can be subject to different types of sick leave benefits, and understanding which of those benefits apply on which work days if the worker needs to call out can get quite burdensome. One solution to both the remote work and the mobile worker issue is rolling out what we call one size fits all or one size fits most paid sick leave policies. One size fits all, as it sounds, you take all the laws that you are triggering based on your operations and you cover all of them in a single policy. One size fits most, you have a main policy that provides a certain threshold benefit to the overwhelming majority of your workers, and then you have outlier laws covered by an addendum or a supplement or carve-outs within that main policy. Either way, you're looking to cover the overwhelming majority of your workforce through a single main policy. So if I'm an employee who has a work site in New Jersey, but I'm working from home in New York, and occasionally I spend time in my company's work site in Connecticut, all three of which have paid sick leave laws, and I need to move around from those different locations depending on the work week. If I have a main policy covering all three of those laws and the most generous aspects of them, it doesn't matter what site I'm working from. Right? That's one of the main benefits of these one size fits all, one size fits most setups. And plenty of companies today are spending some time doing the legwork of assessing whether I need to make some tweaks or adjustments or maybe even overhauls of my paid time off program in light of COVID and the changes it's resulted in the workforce. A couple of other notes about these 2 points quickly. Number one, For remote and mobile workers, as a broad statement, there are exceptions for sure to this, but as a broad general statement, there are a majority of paid sick leave laws that will apply to an employer regardless of whether it has a certain threshold number of workers in a jurisdiction. So if you have only one person in that state or municipality, you could be covered. And regardless of whether you actually have a physical work site there or not. There are exceptions to that rule, but most paid sick leave laws will cover an employer even if you just have one person there and even if you don't have a physical site there. Similarly, from an employee eligibility standpoint, there are a handful of laws, maybe even a decent number of them, that have criteria for eligibility. You have to work a certain number of hours, or this needs to be your primary place of work. You have to average a certain number of hours per week. Some laws will exclude certain types of workers from eligibility, maybe exclude exempt employees from eligibility. But as a broad general statement, most paid sick leave laws will apply to all private employees, including not just full-timers, but also part-time and temporary employees too. Both of those become really relevant in the remote work, mobile worker context. So keep all of that in mind. One size fits all, one size fits most. So a couple of final thoughts there. The one size fits all point, it's worth noting what that really looks like in practice is a huge windfall for workers. Companies will often ask, what can we do to squeeze all these laws into a single umbrella? And often the response is, well, you can have no cap on accrual, no cap on how much time they can use per year, and no limit on how much unused time they roll over at year end. The only difference really between that setup and the types of unlimited routine time off policies or unlimited sick leave policies you'll hear Tracy and Anne-Marie speak about in a few minutes is that there is an anchor based on the hours worked. There is still accrual of sick leave based on the employee's 1 hour for every 30 hours worked rate. But otherwise, no caps on accrual, use, and carryover can lead to a pretty significant windfall for workers, especially those who work in a jurisdiction with no paid sick leave law. You also have to factor in the most generous aspects of the paid sick leave laws, beyond the numbers, right? Reasons for use, increments, notice and documentation, rates of pay, among other topics. There are some benefits to one size fits all. Those include having a single policy, easier for administration, good for worker retention, should hopefully cover most future developments of paid sick leave in the patchwork. But certainly the big windfall is a major downside. One size fits most policies can take a whole different host of forms, and we work with companies every day on figuring out what makes sense for their operations. Some companies design these policies based on region and geography. Some develop one size fits most policies with different tiers of benefits. And they all depend on different factors, and we'll go through a process of analyzing which factors are most important and prioritizing them for companies. Relevant laws, the nature of your current benefit time off program and your attendance and discipline policies, level of risk tolerance, the potential penalties under those laws, the level of enforcement under the paid sick leave laws, the nature of your workforce in terms of mobility, remote work, part-timers, union workers, federal contract work, and so forth, and even the sophistication and capabilities of your payroll and timekeeping systems, your HR and your benefit teams that are administering the policies, and so forth. All of those factors will be brought into the considerations for a one-size-fits-most policy and what it should look like. Final two quick thoughts from me on written policy requirements and non-policy requirements. There are a number of paid sick leave laws that have some type of written policy mandate. So they expressly say either you have to have a written policy and it needs to include topics A, B, C, D, E, or they say you have to include these topics, notice or documentation or unlawful retaliation protections in writing, in a written policy. So as you're working through one size fits all, one size fits most considerations, some language that written policy mandates require to be there might seem out of place in a multi-state policy, which might lead to additional addenda or supplements. There are many practical benefits to having a written policy, even if a law doesn't mandate it. Compliance for sure, protection if you get audited. A lot of these agencies will want to see written policies on the ground to know what your program and benefits look like. Less worker and manager confusion, good for worker retention and recruitment, among other things. Finally, once you've done all the legwork, you've drafted the policies, you've gone through all the red lines and comments and accepted the track changes, buttoned up what the policy should look like, and then you have all these other non-policy requirements to deal with. programming, getting your record keepings in order, making sure that notice is given to new hires during onboarding, right? The right balance information is put on pay stubs or in your company portal. You're paying workers at the right rate, among other topics. All of those aspects are governed by paid sick leave laws. They all have these non-policy requirements as well that companies need to be aware of. We're going to be spending a few minutes during our next paid sick leave webinar series event on these non-policy requirements. So more coming on those topics. With that, I'm going to pass it over to Anne Marie to just talk a few minutes about California considerations in the paid sick leave policy world.
Thank you very much, Josh. So everything that Josh, actually, if we could go back one slide, thank you. So everything that Josh has just discussed applies in California, but there are a couple of California-specific considerations that I want to highlight for you. First, I'm often asked, well, is it possible, we don't want to have a one-size-fits-all policy across the country because of the downsides that Josh just mentioned, but what about a one-size-fits-all policy in California so we can at least cross California off the list? And the answer is yes, it is possible. However, a lot of your California employees, specifically those outside of San Francisco, Oakland, and Berkeley, which are the overall the most generous paid sick leave ordinances, are going to receive a significant windfall. So very few of clients I've counseled have opted to go this route. In a nutshell, what a one-size-fits-all California policy will look like is an accrual policy under which employees accrue 1 hour for every 30 hours worked up to a point-in-time accrual cap of 80 hours. San Francisco, Oakland, and Berkeley are 72 hours, but San Diego is 80 hours. That's where the 80 hours comes from. All 80 hours would need to carry over to the following year to the extent that they're unused. And there is no annual use limit. So it is a very generous policy and a policy that most California employers do not want to roll out, especially in locations where there's only the statewide paid sick leave law, because the California statewide law, if you use an accrual method, it's a cap of 48 hours or 6 days, but significantly there's an annual use limit of 24 hours or 3 days. So, giving somebody, an unlimited use, on an annual basis and a carryover of up to 80 hours is pretty significant windfall. There is a possibility to do a sort of a rather than just one size fits all in California or location by location, you are able to do a one size fits most in California and have specific addenda for the more generous California jurisdictions. However, you really do need to use an accrual policy if either one size fits all or one size fits most, because jurisdictions like San Francisco don't really allow for front loading. You could advance accrual, but the front loading option really isn't available. So with that, I am going to turn it back over to Josh to kick us off on PTO considerations.
Thanks, Anne Marie. Next two slides, please. So as Anne Marie mentioned, right, a lot of those topics we just discussed in the paid sick leave compliance context apply in California when you're dealing with just paid sick leave. They also, as I mentioned about 10 minutes or so ago, will also for the most part apply if you're going the PTO for paid sick leave law compliance route. So one size fits all versus one size fits most, written policy requirements, complying with the non-policy aspects of those laws, those also all come into play in the PTO context. On top of that, as you can see on this slide, there are a number of other legal challenges and considerations when you're dealing with PTO for paid sick leave law compliance that make it a burdensome, cumbersome process. Not to say that companies don't do it, and not to say that it is not permitted, because most, if not all, non-COVID paid sick leave mandates do permit using non-sick paid time off for paid sick leave law compliance. Whether to do it, on the other hand, whether your system and your operations and your company can handle all the different nuances and challenges, that's an entirely different question. But here are some of the highlights to think about if you are considering moving to PTO, or perhaps wondering if your PTO policy is up to par with what the sick leave laws bring to the table. For starters, there is this, what do I have to do to use paid sick leave for sick leave law compliance? And it's not a single standard, but the general overview for the non-COVID paid sick leave laws is that you have to meet 3 criteria. Number 1, you have to provide the right amount of time off. So those are the usage caps and accrual rates and accrual caps and year-end rollover that we just spoke about. Often those numbers are pretty easy to satisfy through PTO, because PTO is usually 10, 15, 20 days, whereas sick leave laws are usually bringing 40, 48, 56 hours to the table. Year-end carryover of those topics is often the one that trips up employers' PTO policies, depending on the specific location. But not a super heavy lift to get across that hurdle. The next of the 3 criteria is that you need to make the PTO available for the same purposes as paid sick leave, which means all the covered reasons for use, all the covered family members, which is another low-hanging fruit, because PTO can be used for any reason, including paid sick leave needs. So that is also a fairly easy hurdle to jump over. The last one is the one that tends to give employers the most challenge, and is the one that is often the most overlooked, and that is this concept of the same conditions as statutory paid sick leave. What that means is the paid sick leave law standard will say, in order to avoid having to give additional paid sick leave to workers and get credit for your PTO program or your vacation time program, you not only have to give the right amount of time and make it available for the right reasons, but you have to subject that time to the right sick leave conditions. And sick leave conditions can mean, a dozen things, 15 things, 20 things. There are so many different substantive topics within each of these laws, and just one of them, let alone 20, 30, 40 of these laws, that becomes a really uphill battle for companies to understand and comply with. It is doable, but it requires a lot of careful attention to detail, both with the policies and with your programming behind the scenes. Some of these conditions, examples of them include increments of use, waiting periods for new hires, documentation, the notice the workers provide to the company, avoiding anything that could be deemed unlawful interference or unlawful retaliation, paying at the right rate, among many other topics. When you're thinking about these same conditions, think about a basic vacation or PTO policy, right? Often they will say that the time needs to be used in full or half-day increments, or that manager approval is required. We'll do everything we can to approve the time off, but we might not be able to in certain circumstances. Or that if you don't have an approved absence and you call out at the last minute, you're going to get dinged under the attendance policy. Or 14 days notice is required. Or 6 months, you have to be with us for 6 months or 12 months before the benefits are available. And on the examples go. Each of those different elements of a PTO or vacation policy would be violating a condition of the paid sick leave law, right? Each of those topics would not mesh well with the paid sick leave mandate. And that's why the same conditions concept is such an important topic. How do we get around the same conditions or comply with the same conditions obligation? There are different options for sure for companies to think through. We deal with them every day with our clients. One of the big ones is the need to track why the PTO is being used. Now that inherently butts heads with the concept of a PTO policy, because most companies don't want to have to track PTO. If they did have to track why PTO is being used, they would have just stuck with their separate buckets of vacation, personal, and sick time. But tracking why the PTO is being used and knowing when it's being used for covered sick leave reasons gives the company the opportunity to apply the right conditions to that time, to make sure that the worker isn't being disciplined, as part of an attendance or other discipline policy that the company has to make sure the right increments are being applied, the right rate of pay, and so forth. So tracking why PTO is being used, setting up your systems, making sure workers are aware of what codes to use in what situations, that managers and human resources personnel are aware, all become important in this context. As you'll now hear from Anne-Marie, there are some other really important topics as well, including state vacation time law aspects.
Thanks very much, Josh. And yes, so if you are using a PTO policy to comply with sick leave, there are a number of states that have laws on the books governing vacation as well as PTO. In most of these jurisdictions, PTO is treated exactly like vacation. And so if you happen to be in one of these states, your PTO policy is going to have to comply with these requirements. So the first requirement I want to highlight is really PTO carryover. So a number of states, including my home state of California, additional states are Colorado, Montana, and Nebraska, have laws on the books that prohibit forfeiture of accrued vacation or accrued PTO. So what that means is all accrued unused PTO will need to carry over to the following year. As Josh mentioned at the outset of our program, in most, but not all jurisdictions, if you use the front-loading method for paid sick leave, in most jurisdictions, you can have a use it or lose it policy, meaning, if at the end of the year, employees forfeit their unused paid sick leave, and on the first day of the new year, they receive a new lump grant. So under the PTO option, in a number of states, it is not possible to forfeit, unused time at the end of the year. Additionally, a second consideration is a number of states, again, my home state of California required that accrued unused PTO be paid out on employment separation. And, this is a significant consideration for you if you happen to be in one of these states, because other than the Oakland, California paid sick leave ordinance, paid sick leave is not, unused paid sick leave is not required to be paid out on employment separation. So as a result of using PTO, you will, in these locations, need to pay out your PTO. The third consideration I want to highlight is just a number of paid sick leave laws. Even if you're not in a jurisdiction that requires that PTO or vacation be carried over to the following year, a number of paid sick leave laws do have this consideration or requirement. So if you had separate policies, for example, for vacation and sick, at the end of the year, your state law may allow you to provide that employees forfeit their unused vacation or unused PTO, again, if you had a separate sick. But you won't be able to do that if your sick leave law, your applicable sick leave law, requires that unused paid sick leave roll over to the following year. If you're using PTO, all of that time is lumped together, and so all of that time is going to carry over to the following year. And then finally, the fourth consideration, very important consideration that I want to highlight is I would say the overwhelming majority of PTO policies that I review in my practice, if they're not being used for paid sick leave, they will provide that employees don't begin to accrue paid sick leave until they've worked for the organization for a certain period of time. If employers have an introductory period, it's usually upon successful completion of the introductory period. Otherwise, it's could be 30 days, 60 days, 90 days, or I've even seen policies that say for the first 6 months of employment, employees do not accrue PTO. So virtually all of the paid sick leave laws provide that paid sick leave accrual begins upon the employee's date of hire. So you will need to modify your PTO policy, and as a result, you will have employees begin accruing PTO, which again can be used for any reason, including vacation. So they'll begin accruing on day one of employment, as opposed to, say, 6 months down the road. So as a result, new employees will have greater access to paid time off sooner than they otherwise would if you weren't using your PTO policy to comply. Another consideration I want to talk about is additional protected time off that employees receive if you use a PTO policy for compliance as opposed to a sick leave policy. So first, there are two different issues. The first is that virtually all of these paid sick leave laws and ordinances have a non-retaliation provision, which essentially means that employees cannot be subject to any adverse action for using their paid sick time. Can't be subject to termination or discipline, can't receive attendance points for their absences, etc. And then significantly, they also define paid sick leave. A number of them do not define paid sick leave under their statute to the time that is required under the particular statute. Let me just give you an example. So California only requires, if you're using accrual method, like I said earlier, the accrual cap is 6 days or 48 hours, but the use limit is each year is 3 days or 24 hours. But the California paid sick leave law provides that employers may not retaliate or treat any employee adversely for using paid sick days. And it does not define paid sick days as the 24 hours or 3 days, or even the 6 days or 48 hours. Instead, the definition is all paid time off that an employer makes available for the reasons covered under the statute. Well, PTO can be used for any reason. So, so there is, this argument that if you use PTO, that any PTO that you provide is subject to the non-retaliation provision of the sick leave law, assuming, of course, that they are using it for a covered sick leave reason. Your PTO is not going to be protected, for example, if an employee is off to Hawaii. But if they are using PTO for a reason covered under the statute, they conceivably have much more PTO or paid sick leave available for legally protected reasons. And that is because you read the non-retaliation provision in conjunction with the definition of paid sick time. Now, even if that isn't the case, even if your particular statute doesn't define paid sick leave broadly and it only protects the minimum amount of time that's required under the statute, you also need to look at whether your jurisdiction has a kin care statute that protects more time than just the time that's protected under the paid sick leave ordinance. So there are a number of states, I think it's up somewhere between 12 and 15, jurisdictions have these kin care statutes. They include California, Illinois, Georgia, a host of others. And so what these laws do is they don't require employers to provide sick leave. But what they provide is that if employers do provide paid sick leave, either because they want to or because they're in a paid sick leave jurisdiction, then a certain amount of that paid sick leave or paid time off. So these KinCare laws apply to paid time off. They do not apply to vacation because they only apply to laws that provide paid time off that can be used for sick leave reasons. But what they do is they provide that a certain amount of that time, which is always going to be more than what the paid sick leave law protects. So in California and Illinois, for example, it's the amount that's protected under the KinCare law is what the employee would receive and have available over a 6-month period. So all of that time is protected under the KinCare law and therefore cannot be held against the employee for using that time for a KinCare reason. Now, in all jurisdictions except for California, that KinCare reason is sick leave to care for a covered family member. In California, the statute was amended a few years back, and so KinCare now protects sick leave that is used for any of the reasons covered under the state sick leave law. So the bottom line with KinCare is that if you use a PTO policy to comply with sick leave and you are in a KinCare jurisdiction, employees are going to end up with a lot more of PTO that they can use for paid sick leave reasons. That will be protected, which means that employees cannot be subject to discipline or points or any other negative impact as a result of using that PTO time. And this KinCare consideration would not apply if you had separate sick and vacation policies, because of course your sick time is going to be protected under the sick leave law. But like I said earlier, that's just the sick leave protection. And your vacation would not cover KinCare, and so none of that vacation time would be protected. So I know that this is a complicated area. If you have questions and want more information, feel free to reach out to us, because I could talk about this one particular topic for the entire 1-hour webinar, but certainly don't have time to do so. So with that, I'm going to turn it over to Josh just to briefly highlight a couple of PSL considerations, and then we will turn it over to Tracy to kick off our discussion about using unlimited time off policies.
Thank you, Anne-Marie. Appreciate it. Thank you. So,
absolutely.
So yeah, just very quickly, the paid sick leave law considerations that are also out there is worth keeping in mind too. That when you're thinking about tracking PTO, as we spoke about a few minutes ago, balance notice requirements become a really thorny issue in the PTO context, whether you're going to report the entire PTO balance to workers or just their PTO used for paid sick leave reasons. So that becomes a really important consideration. There are some jurisdictions, in addition to California, Seattle, Washington, New Jersey, Colorado, where using PTO for sick leave compliance is particularly challenging, given some guidance or the interplay between certain laws. Despite everything Anne-Marie and I have gone over the last few minutes, there are still plenty of companies that are looking to use PTO for paid sick leave law compliance. They use them because the policies are generous, are flexible, seen as being good for retaining talent, a differentiator from their competitors, some administrative ease, and as Marlon mentioned all the way at the beginning of our presentation today, a few locations, Maine and Nevada, for example, have been starting to come out with PTO mandates rather than paid sick leave mandates. All right, we're going to turn it now to the final substantive topic today, which is unlimited PTO considerations. And Tracy, the floor is yours.
Thank you very much. I appreciate it. Next slide, please. So we regularly get questions about, well, why don't we just have an quote unquote unlimited PTO policy It'll make our lives easier. We don't have to worry about things. We don't have to track things, right? People just take whatever time they need. I wish it were that simple. We're going to talk about a number of considerations that can come up and what employers can and cannot do related to these unlimited PTO policies. And many of the things that you just heard Anne Marie and Josh speak of, they don't go away in the context of unlimited PTO. So the record-keeping requirements, the balance notifications, ensuring that people are being paid accordingly, increment usage, all of those things. Next slide, please. So in terms of some things that come up, number one is abuse. If you are going to be using a routine time off, and I like to use the word routine time off as opposed to unlimited paid time off, and Anne Marie will disagree with me from a California perspective in just a moment, but that's because, again, it's California. But across the rest of the country, I like using routine time off because really at the end of the day, nobody is truly providing quote unquote unlimited time off. You have work to get done. You have clients that need their needs met. You have goals and productivity concerns, right? And so number one, with these policies, understand if you're using them, there is no cap on the time that someone you can use. You can't say, for example, there's an unlimited PTO policy, but by the way, you can only take 80 hours of paid sick leave under this policy. It truly does mean, right, that there's not going to be a cap here. You also still have the PSL and PSL tracking and payment requirements. You also need to provide the procedural aspects of the paid sick leave laws. As you heard from Josh, lots of them are very particular about notice, when you can do it, when you can't, documentation, all of those sorts of things. In a traditional unlimited PTO policy, none of that is really codified because it's meant to be a very flexible program. Also, don't forget, as Josh noted, there are many jurisdictions that have PSL written policy requirements. They will have to be added to your unlimited PTO policy if you are using that for compliance. And many people don't want to include those in there because it kind of takes away from the overall feel of the unlimited program. And last but not least, if you are transitioning from a current accrual-based program to an unlimited policy, you really are going to want to be partnering with counsel in doing so. There's a number of state wage and hour laws that dictate what can and cannot be done with the time, whether it can be forfeited, whether it has to be rolled over, whether it has to be paid out, whether you can require employees to work it down before the transition. So just know that it's not so simple as going from an accrual-based policy to an unlimited, because there are a number of jurisdictions where this is highly regulated. And as if Anne Marie didn't know that that was the nice segue to California, highly regulated, here we go.
Thank you very much, Tracy. Next slide, please. So just a brief California call out. We very strongly do not recommend using a no accrual or unlimited time off or routine time off policy to comply with California paid sick leave obligations for really two separate reasons. The first is, despite their popularity, including in California, it is by no means clear that an unlimited time or no accrual policy is even lawful in California. And that's because California law typically regards, well, it does regard accrued vacation as wages that may never be forfeited, either during employment or upon separation of employment. So the very real risk is that this type of policy will be found to incorporate some sort of de facto accrual and at a rate based on communicated expectations or express limitations or other facts. So, for example, if you have a so-called routine time off or unlimited time off policy, and your managers are telling employees that they won't approve their request because they've already taken 2 weeks, or, you know, we don't allow people to take more than 3 weeks at a time, you could be found to have a de facto accrual policy. The second reason is because even if such a policy is lawful, use of this type of policy to comply with California paid sick leave obligations arguably results in truly unlimited, legally protected time off for California employees. And that is because there is a California requirement to include available sick leave on employees' wage statements or in a separate writing that you provide to employees each pay period. So the California Division of Labor Standards Enforcement has said that if you use an unlimited policy, you need to put unlimited for the sick leave balance on the pay stub. And that really is not a workable option for nearly all employers. So with that, those are the two reasons. We've included some additional material on your slides that explain the state of the law in California and also quote for you the DLSE FAQ that provides the pay stub guidance I just mentioned. And so with that, I'm going to turn it over to Josh to wrap us up for the day.
Great, thanks, Anne-Marie. Just go next couple of slides. So there's all the background info Anne-Marie mentioned on this McPherson decision. I'm first going to read out the CLE code for folks. The code is SS, as in Seyfarth Shaw, 8291. Again, SS 8291. And just go to the next slide for me, please. We have some amazing resources available, a stellar team of experts on all things paid leave all around the country. If you want to sign up for our paid sick leave mailing list, you can see the sign up link is right there on the slide for you. We also have multiple comprehensive paid leave surveys, including a paid sick leave survey. If you want any more information on those potential resources, paidleave@seyfarth.com is the way to reach out to us about those. Thank you so much, everyone, for joining us. Please be on the lookout for the webinar recording and slide decks, and we'll also be on the lookout for information on our next paid sick leave webinar series coming in about a month or so. Thank you, everyone. Be safe, be well. Thanks for joining us.
Thank you.